In this lesson, we're going to look at attempts or inchoate offenses. First off, inchoate refers to incomplete or offenses that have not been committed proper. Now, the punishment is not for the main offense, only for the attempt itself. Now, you might wonder what the purpose of this itself is, and quite frankly, the purpose is practicality. If there was no such thing as attempts or inchoate offenses, the police would not be able to arrest burglars, robbers, murderers until the robbery has taken place, so until the theft had taken place. If they have evidence, if they have proof that such a thing is going to occur, and if they are unable to arrest at that point, it seems quite redundant and without purpose to wait until said crime is committed. So attempts actually plays a quite pivotal role. Inchoate offenses plays a quite pivotal role in the criminal legal system. Now we must consider attempt in several formats, because while it is not complicated, there needs to be a definitive demarcation and a distinction between where a particular crime becomes a crime and merely an attempt. Now, Section 1, Subsection 1 of the Criminal Attempts Act 1981 defines an attempt as something which is more than preparatory. As in, different actus reus might apply for the offense itself, but whatever the actus reus is, it must have been fulfilled at least 80%. It must be more than preparation itself. It can't be merely an individual planning to do something. He must have gone officiously and done quite a substantial bit, perhaps not the last act itself. Now, how exactly can we put this in context, as in relation to the actus reus and the mens rea components of an attempt? Let's take 3 specific examples and let me outline where they fit in relation to criminal law. For instance, let us say the defendant D suggested that I want you to kill John. This doesn't refer to an attempt. It is merely incitement. It is inciting a person to kill John. Secondly, let's consider a statement such as I must kill John. This falls under conspiracy. It is an intention. He has not actually committed the crime nor taken any preparatory steps. Thirdly, let us assume that he intends to kill John, does everything up to that point, everything more than merely preparatory, and at that point the result doesn't occur. We'll consider it as a complete attempt. That might be considered as an inchoate offense or an attempt itself. So the actus reus can be considered as an act which is more than merely preparatory to the commission of the substantive offense. And the mens rea, or the internal mental component of it, is the intent to commit an offense. That intent must be operative, as well as he must either intend the result or the conduct, depending on whether it's a result or a conduct crime, as well as intend the consequence as well, as I mentioned, the result of it. So basically, the mens rea component must officiously be complete, and only the actus reus element must be on the limb or to be completed. Now, in line with this, we can consider attempts in 2 separate sections. One as complete and one as incomplete. Now, we noted that an attempt is where a person has gone beyond preparation but not committed the crime itself. So, in relation to a complete attempt, it means that he or she has taken all steps necessary, including the final act itself, but the intended result had not occurred. Whereas an incomplete attempt might be not having taken the final step, but done everything up to that point. Either way, we must consider that an attempt has been made, and the individual, the defendant, can be held liable for that attempt as well. Now, this was a brief outline in relation to attempts or inchoate offenses. Something that is important in an examination situation, because most questions might involve an individual having done the requisite elements of the actus reus, having an operative mens rea, but the question will outline that the result or the crime itself had not occurred. In such a situation, a good student will always outline the possibility of that particular individual or the defendant being charged for an attempt of a crime rather than the crime itself. Now, we are going to conclude the introduction portion of this course by looking at our next lesson, which is parties to a crime. Hi, my name is Shavin Bandaranaike. Thanks a lot for watching this video on YouTube. For the complete course, make sure you click the link on the left. Also, for an exclusive discount to YouTube viewers, enter the coupon code YouTube at the course page. All the very best with your studies and good luck with your exams. See you in the next lesson.